Good evening to everybody to the private international law, that is advanced private international law, that we are dealing the matrimonial issues. There is a conflict of class in the matrimonial issues, and yesterday that we dealt up to the marriage age. Now read what I posted on the screen. Anyone? Unmute and read what I posted on the screen.
Conflict of laws, private international law. Bullet 1, conflict of laws. Term systems from Urich Harbor, Netherlands. Nowadays, used primarily in the United States, Canada, and increasingly the United Kingdom. Private international law terms first used by Joseph Story from USA.
Yeah, there is a problem in the internet. Don't worry, that I mute it now. Private international law, the term used by the Joseph Story, within parentheses USA in 1834. Mute. Mute.
Used in most other countries and in the United
Raymond, there is a problem in your speech. Break the voice. You mute it now. You mute it. Okay. Right. Private international law term first used by Joseph Story, USA in 1834, used in most other countries and in the UK also. But in the common law countries, especially Asia and Asian countries, we do use the private international law, but we don't say the conflict of laws. Both are the same. So yesterday in my class, we are dealing up to here. The essential validity covers all the questions of validity other than the formal validity. There is a capacity to marry is a category with essential validity. Capacity to marry ought strictly to be confined to rules which lay down the particular class of the person's lack of power to marry, which other people possesses. For instance, rule that a person below a certain age may not marry. Up to that extent we dealt yesterday. Now in this class, now we'll see that in practice, however, capacity to marry also include cases where the reason for the invalidity is that such a marriage relationship is objectionable in the eye of law. For instance, rules prohibited marriage between the relatives of certain degrees, like a consanguinity of the marriage, are prohibited in Tanzania as well as in India. Capacity to marry does not, however, cover the whole field of essential validity. It does not include the consent of the parties or non-consummation of the marriage. So up to that extent we studied over there. Because in the Muslim marriage, consummation is must. Then only it is fulfilled that the marriage is completely done. So that was the point over there. There is a general agreement that this terminology includes the matter of the legal capacity such as a consanguinity, blood relationship, and affinity. Affinity comes from the mother's side. And bigamy means a person, if you are already having the wife and get it married with another second one, then we can say the bigamy. At the lack of age, and of course, at the time children marriages are there high in that in India, of course in Tanzania also, but now no children's marriage would be there. Consideration is given a later to a law to govern the matter of the consent and physical incapacity. So when you want to marry, the capacity is very important factor, number one. Number two, all the conditions which is laid down in the Law of Marriage Act should be fulfilled. If they are the domicile of the Tanzanians or as Tanzania citizens, and where the marriage is conducted over there, the formality of that marriage would be followed over there. But where the matter for the substantial law is concerned, it depends upon the boy or a girl, or a male or a female, and a man and a woman, and their domicile is considered over there. So that is the whole gist of it. The fact that the capacity is a term encompasses a wide range of the matter does not necessitate a conclusion that all matter of capacity should be subject to the same choice of law rule, matter to which we shall return. So when you say the capacity, it varies from country to country, but the international instrument says that they have to follow 18 years, 21 years, that is the capacity to marry will reach over there. Then a further preliminary point which ought to be borne in the mind is that provided that a person has capacity under the relevant law, the fact that he is, for example, under age according to the English law will not invalidate the marriage in the eye of the English. Underage marriages are not invalid at the time, but now it will not be considered as a valid marriage. The law of the forum, at least, if the marriage is not in England, there are two main views as to the law which should govern the capacity to marry. What is that? The dual domicile doctrine and the intended matrimonial home doctrine. And we don't have the dual domicile doctrine here. Only one domicile will be considered and one citizenship. The intended matrimonial home doctrine means where they have born, and that will be considered, and where he has brought up, and where his father lives, where his mother lives, and that will be the domicile of their child. So, consent of the party, next we will see that. Here they have given the only theoretical aspects of it. Consent of the party is necessary or not. If you see the Tanzania, yes, consent should be necessary. Whose boy and a girl or man and a woman. So the rule states that no marriage is valid if by the law of the either party's domicile or she does not consent to marry the other. The consent is a must, and there appears to be no specific authority in England on the subject, though observation by the Court of Appeal in a case where the issue was whether the marriage by proxy was valid. Yes, in the Muslim law, when that a reasonable ground would be there, the proxy marriage is valid. What about in Tanzania? I don't think that proxy marriage is valid in Tanzania. What do you say? What do you say? Participants.
No, sir.
Oh, there is a problem of your internet. Breaking voice is coming. In the beginning, it is very good, but now it is a breaking voice.
Person, sir.
Yeah, the proxy marriages are not there, as far my knowledge goes forth. So, observe the mode of giving consent as opposed to the fact of the consent would be governed by the lex loci celebration is where the marriage is conducted over there, that formality should be followed. It is a correcting factor. It was also held that the consent is governed by the law of the domicile of the parties. Yes, it is the law of the domicile placed in the common law countries. Lex patriae, law of the nationality, plays a role in the civil law country. The question that arises here as to which lex domicile has to be considered of both the parties or of the parties whose consent is in a question. The consensus seems to be, though there is no decision on the subject, that is, should be domicile of the person who is alleged to have the lacked consent. So now the whose domicile will be considered? Man domicile or woman domicile? The point is, substantial law is concerned, yes, both domicile will be considered. If the procedural law is concerned, lex loci celebration is, and where the marriage is going to be solemnized, that procedural law would be followed in that country. Let us see the one of the case law, Davison versus Sweeney. I repeat, Davison versus Sweeney, it was held that alleged absence of consent was a matter of for a domicile of the party concerned. So, domicile of the party concerned, there it will depend upon whether consent should be necessary or not. But for the boys or the girls, or the man and woman, consent is must. But in certain places, whether the parents' consent is necessary or not, that will be a different issue. It depends upon the type of the marriage will be conducted over here. In Canada, consent is regarded as the part of the essential validity of marriage and depends on the antenuptial domicile of the parties. So the consent is necessary in the Canada, and even the anti-domicile of the parties are considered. The nuptial domicile of the parties, those who are going to be married, for the engaged over there, their domicile will be considered to know whether they have the capacity or not to marry, or whether there is any prohibition to marry or not. So let us see what are the choice of law rules. Here the choice of law rules means formal validity is governed by the law of the country where the marriage is celebrated. Generally, there is a formal validity. Lex loci celebration is. The law is not generally through the appropriate in the English conflict of laws to govern the essential validity. This is because the marriage may be celebrated in a country which in other respect has no connection with the marriage of the parties. Neither of the parties may be domiciled there before the ceremony and they may not establish their home there after it. The choice of law rule doctrine as under. In case nobody's domicile would be there, but if another country they went over there, they would like to marry. At that instance, what is the choice of law is there and how the marriage would be conducted. The question comes, if it is a common law countries, they follow the lex domicile of the parties, and if it is a civil law country, we will follow the lex patriae, that is the nationality. But they say dual domicile doctrine. According to the dual domicile doctrine, rule is that the person domicile at the time of the marriage has to be considered. For a marriage to be valid, each party must have a capacity by the law of his or her domicile to contract the marriage. Yes, the party's domicile is the important factor to know the capacity. This rule commands most in English law and has several advantages. In terms of the principle, it is appropriate that the people governed by the law of their existing domicile. Domicile plays an important role, and here the main rationale of this rule is that person's status in a matter of public concern to the country to which belongs to at the time of the marriage. At the time of the marriage, what is the domicile of a person? Later, he can want to change it, he can change the domicile also. And therefore, domiciliary of the law, each party has an equal right to be heard. And each party domicile will be considered to know the capacity is there or not of the parties. Another advantage of the doctrine is that it is easy to apply the prospective situations. They say, whenever the marriage is conducted, and we will see the domicile of a person for the substantive law, for the procedure law is concerned, or the formality is concerned, it will be considered where the marriage is going to take place. That is actually the thing. These are all the gist of it. Intended matrimonial home doctrine. So once they married over there, they will decide whether to continue in the domicile of their choice or domicile may be acquired by losing the domicile of their birth. An alternative approach is that the law of the intended matrimonial homes governs the essential validity of marriage. This provides a basic presumption in favor of the law of the country in which the husband is domiciled and the date of the marriage. At the date of the marriage, what is the domicile of a husband, that will be considered. This presumption can be rebutted if at the time of the marriage, the parties intended to establish a matrimonial home in the different country. Suppose if they want to settle completely in the different country after the marriage, the issue may be the different. At that time, they will lose the domicile by birth and they will acquire the domicile of choice, the place where they want to live permanently after the marriage. Matrimonial home in the different country, and if they implemented that the intention within a reasonable time. Of course, they have to inform that they would like to marry, they would like to stay over there permanently after the marriage. That intention would be there. At the time, there would be matrimonial home doctrine would be applied over there. The intended to be stay over there, that would come into the picture. Okay, real and substantial connection, another possibility in that essential validity of the marriage should be governed by the law of the country with which the marriage has its most and real and substantial connection. So a marriage, how it can be made, where the substantial connection with the parties would be there to the country, and that country law would be applied. As with the intended matrimonial home doctrine, this rule is trying to connect the marriage with the country in which it belongs. Normally, the country with which marriage is most closely connected will be the country where the matrimonial is situated. So, most connected with the country means where they have born, where they have got up, where they have grown, where they are doing the employment, and that country most closely connected with the country where the matrimonial home is situated. If they want, they can change also, because there is no permanent thing. A domicile can be acquired by losing the domicile of their origin by birth. Further, while the real and substantial connection test has its supporters, it is in reality the question begging test. The question in which choice of law rule will be best lead to the application of the law to which a parties and a marriages belong. The test does not answer the question, but rather simply restate the problem. And whatever the thing is going to make it out, there is domicile is considered over there when the marriage is going to be conducted for the substantial law. And the formalities of the marriage will be conducted where the marriage solemnized in that country. Lex locis celebration is. That is the total gist of this everything. Now let us see the matrimonial cause, and matrimonial causes are now generally taken to include the petition for the divorce and nullity of the marriage. These are all the matrimonial causes. What are they? Read. What are they? I don't know whether your internet is good or not. Dorcas. Matrimonial.
Yes, Prof.
Matrimonial causes means here it is highlighted. No. See, this is what I highlighted now here. The cursor is there. Read.
Matrimonial causes are civil cases. Okay. Matrimonial causes are now generally taken to include petition for divorce, nullity of marriage, judicial separation, and presumption of death and dissolution of marriage, as well as similar foreign proceedings which may fall recognition here.
Yes, that is the matrimonial causes. Divorce, marriage, nullity of marriage, judicial separation, presumption of death, dissolution of marriage, and sometimes the foreign proceedings also will be considered. These are all set with the matrimonial causes. The rules relating to the jurisdiction of the court and the recognition of the foreign divorces, annulment and judicial separation are in the essence the same for all three matrimonial causes, therefore be examined together identifying where appropriate any rule which don't apply all three. Here, the rule may vary from country to country. And what is the justification would be there to the parties, the judges will apply that theory and they will give the judgment. So it will be seen that one major area of difference remaining concern of the determination of the law to be applied in English courts, it is also necessary to discuss further preliminary issues, namely whether an English court will assume jurisdiction to grant the matrimonial relief in the case of an actually or potentially polygamous marriages. Of course, polygamous marriages will not be now. It is prohibited over there, and hence no chance of polygamous marriages. Only monogamous marriages are there now. So marriages and matrimonial relief come in that fashion. But what is the position in the common law? They say, English law, there is no polygamous marriages now. And now the law will be changed over there. Earlier it may be the polygamous marriages are, but now there is no question of polygamous marriages. The court would grant the divorce or decree of nullity even where the petition claimed the lack of capacity to enter the polygamous marriage. We did not discuss because there is no polygamous marriage now, and hence we can skip this one. Of course, we don't have a Matrimonial Cause Act of 1973 because that is no more in our. Do you have such a cause? It is in England. Domestic proceeding and magistrate court. Of course, we do have the Magistrate Court Act in Tanzania. And what you will say? And the Law of Marriage Act would be there. And what are the provisions would be prevailing over there? That will be coming to the picture. Otherwise, there is no question of reading those things. So remaining problems, what there? Where the party to an actually polygamous, there is no question of polygamous marriage. Hence, we can skip this because he has dealt about the polygamous marriage there. But we can say that the jurisdiction. Yes, which court is having the jurisdiction? If both the parties will agree to it, yes, that place have the jurisdiction to entertain either for the marriage or for the divorce. If they agree together. For the substantial law, again they will see the lex domicili. For the procedure law, where the marriage is solemnized, that will be taken into consideration. So that's the jurisdiction will come in the matrimonial issues. Suppose if they married in Tanzania, can they take the divorce in India? Answer is yes, provided both the parties should agree to that one. And the ground for the divorce can be considered. What are the grounds for the divorce would be there in Tanzania? That will be considered and the divorce will be given over there. Because they are the domicile of the Tanzania. So let us see the one of the case law, Privy Council, what it is given. It is a classical case law. Hapte versus Hapte and Lee Moser versus Lee Moser. There are 3 or 4 case laws are there, a landmark case law, and which will give a clear-cut idea about how a marriage is under the private international law could be entertained. So Lee Moserier versus Lee Moserier case law, according to international law, the domicile of the time being of the married pair affords only the jurisdiction and the only true test of the jurisdiction to dissolve their marriage. So in the case law it is very clearly said, domicile for the time being of the married pair affords. What is the domicile of the married pair? The only jurisdiction and only true test of jurisdiction to dissolve their marriage. Lex domicile law would be taken into consideration to dissolve the marriage, even though they file a case in a different country. Did you get my point? The domicile for the time being of the married pair affords the only jurisdiction and only true test of jurisdiction to dissolve their marriage. That means, what would be the law in Tanzania for dissolve their marriage? And then it will be considered if the both parties filed a case in divorce in India. So they will consider the grounds for the divorce, that is the matrimonial dissolving the matrimonial relations. The essence for the rule in this case was that there should be only one test of jurisdiction and only one court capable of dissolving the particular marriage, the court of the parties' domicile. But earlier view is that where the marriage is conducted, there only the divorce should be taken. But they're not necessarily that the divorce would be taken in the same place where the marriage is conducted. Of course, we don't have the Matrimonial Clause Act of 1937. It is an English case law, the English Act. But sometimes when we need it, we will use the provisions of it and we will see that the justification will be given to the parties. So what the Matrimonial Clause Act 1937 says, the court should have a jurisdiction to grant a divorce in a proceeding by a wife, notwithstanding that the husband was not domiciled in England, if she had been deserted by her husband, or the husband had been deported from the United Kingdom, and the husband was immediately before the desertion and deportation, domicile in England would be there. So these enactments were confined to the proceedings by a wife. Now the position is, they can take the divorce any country, provided the ground for the divorce is based upon the domicile of their country. That is only the condition. So, nullity of the marriage. Yes, again, nullity of the marriage is concerned. British court to entertain the petition for the nullity of marriage was one of the most vexed and difficult question in the whole. What is the nullity of marriage in Tanzania? And what ground nullity of marriage could be taken into consideration? Yes? If you know it, you tell me. If you don't know it, you say pass on. Participants, what are the grounds for the nullity of marriage in Tanzania?
Adultery?
No. Adultery we can dissolve for the marriage. Suppose husband is a important from the beginning.
Yes, Prof. Impotence.
At that instance, a wife can ask for the nullity of the marriage. Not a divorce. Nullity of the marriage only. So certain grounds are there where we can make, of course we have to convince the court. A nullity of the marriage would be there if the husband is impotent. So that is the one of the ground we can say. But you check the Law of Marriage Act, what are the other grounds where the nullity of the marriage will be there? So that will be considered for the nullity of marriage. Is domicile in England on the date when the proceedings are begun? Not necessarily, because at the time of the marriage, what is the domicile of a person will be considered. But later on, they can change the domicile of the after the marriage also. So we can skip this one. And choice of law regarding the divorce is concerned, the question of choice of law has never been prominent in English rule. The conflict of rules relating to divorce, which has always been treated as a primarily jurisdiction question, an English court, when deciding whether to recognize the foreign divorce, has never examined the ground on which decree was granted in order to hand. Here the choice of law is concerned. Which law could be applied over there to take the divorce? Then the question arises, what are the, on which domicile the wife and husband belong? So what are the grounds over there for the taking the divorce or the nullity of the marriage? If the grounds were fulfilled over there, yes, if both the parties may accept, they can take the divorce in other country also. Provided in other country, they will ask the foreign, that is the embassy. In each country there is an embassy. They ask the embassy whether the law is there to take the divorce on these grounds. The embassy will confirm yes. Then automatically the divorce will be sanctioned over there in the court by taking the opinion of the High Commissioner or the embassy or foreign secretary of foreign, that is ambassadors from the which are there in the different country. At that, when the marriage is also solemnized, if it is other than the Christianity is there or any other thing, yes, in embassy marriages will be solemnized, provided both are hailing from the same domicile of the country. In that embassy, the marriage will be conducted. So these are the rules, are the judicial separation. Of course, the time being, they will give the judicial separation after a time bound period is over. Yes, they can, even there is no reconciliation, they ask for the divorce. So at that instance, the exams, if you try to mention the sections, if the section is available, because by that one you will fetch the good marks. If you cite a section of a domestic law, then it will be quite good to fetch the good marks over there. So that is the judicial separation, nullity of the marriage we studied, and ab initio, see the nullity of marriage. A nullity degree is concerned with the validity of the creation of the marriage, unlike the divorce, which dissolves the marriage, which is admittedly validly created. This means that the choice of law is issue a nullity is essentially the same as those already examined in the context of marriage. The reason why the choice of law for the nullity is more difficult area, the divorce, is that the effect of annulment, according to the particular ground issue, they were in a relation to the same ground even within the United Kingdom. Some defect awards a marriage ab initio. What is the defect? Impotency. Some defect awards a marriage ab initio. The defect is impotency of the husband, and which makes a marriage ab initio void, not valid, whilst other merely rendered it voidable. For the other sake, like the divorce or any other thing, like you told, adultery. Yes, if they excuse, it's well and good. Otherwise, it is avoidable, it becomes. It depends upon the parties. If one party is below the minimum age of marriage or is already married, English law regards the marriage was a void. Of course, the marriage is a void because they could not attain the capacity to marry. In Scotland, in other hand, lack of consent also rendered the marriage void ab initio. In other countries like the Scotland, the law says if the lack of consent is there, the marriage void ab initio. Of course, in Tanzania also we can consider the same. Actually, the marriage will not take place at all. Suppose by forcefully it will be taken place and there is no consummation, the wife will not allow the consummation. At that instance, the wife will say definitely that I reluctantly, I was against for this marriage, but my parents forced me to do the marriage and just I was kept quiet. Even if it is proved over there, yes, and no consummation is there, yes, marriage in ab initio, we can take it out. There are further differences in the relation to the effect of an annulment. The annulment of the void marriages has retrospective effect. It declares the marriage never to be existed. It is never to be existed. Means they married not at all. Because if they married with a force. But the free consent is not by the boy or a girl or a man or a woman. It has been suggested that as an annulment of the voidable marriage and divorce decree both only with a prospective effect, the law of the forum should be applied to the former as to the later. So where the marriage is conducted and what is the domicile of their country, and that country law would be applied. But if the formality is concerned, the forum procedural law would be applied. As far as the substantial law is concerned, the party's domicile will be considered. And we already read the recognition of the foreign divorces. Yes, if it is a valid ground, the divorce is given over there. As it is, the divorce will be recognized by the other country also. Provided it is not against their public policy, not against the existing laws and enacting existing laws or statutes over there, even a foreign divorce can be automatically followed over there. It can be implemented. So that we read it very thoroughly in that one. And what is the extra thing is there? At the time of the institution of the proceedings, either spouse was habitually resident in the country where the divorce was obtained. There are certain conditions that are given over there. What are the conditions where we can apply for the divorce? If the mutual consent would be there of both the parties, you can take the divorce anywhere in the world. At the time of the institution of the proceedings, either the spouse was the national of this country where the divorce was obtained. Yes, this is one of the conditions they will make it. And let us see. A foreign decree may be refused recognition on the policy ground. I told you, a foreign decree, if it is against the policy ground of a country, they can reject it. Such a want of proper notice, want of opportunity to take the part, absence of an official document, are contrary to the public policy. It cannot be considered. Either it is a divorce or any other judgment. In conclusion, a contract to marry, fundamentally from a commercial contract, since creates a status with effect both the parties themselves and the society to which they belong. It is fulfilled on the solemnization of the marriage ceremony, and therefore there is a change in the law of the governed relationship between the parties. So whenever the parties would like to marry it, they do have the capacity of that place where they have that domicile. That will be considered. And where they are performing the marriage, the formality of that country would be followed, or procedural law of that country will be followed. There are many different situations in which the existence of marriage must be established as a preliminary to a legal proceeding. The matter may concern many different parts of the law. Thus, the institution of the matrimonial causes, such as the petitioner for the divorce and judicial separation, implies that the parties are related to each other as a husband and a wife. Each legal system must determine the attributes of the consensual union between the man and woman, the common factor in the eye of the law. In English, for every marriage, which are necessary to create the relationship of husband and wife. The above project concludes that the case law just illustrates the incidental question does not attract the mechanical rule. Suppose if there is no valid marriage at all, there is no question of taking the divorce. Because marriage itself, ab initio, is a void. At that instance, there is no necessity of a divorce. Are you following me? When there is a
Yes,
important
sir.
of a man is there, at that time the nullity of the marriage is there. There is no question of taking the divorce will take place. Is it clear? Yes?
No, it is not clear, Prof.
See, marriage is ab initio void. On the ground illustrated in the Law of Marriage Act, one of the ground is impotency. At that instance, when the marriage is void, there is no question of taking the divorce will take place. If marriage is valid, then we can expect to see the ground for the divorce or file a case for the divorce. But marriage itself is void in the beginning, ab initio. Then there is no question arise of the divorce. That's my point.
Understood, Prof.
Yes. So as far as the jurisdiction is concerned, the present situation, you can file a case wherever you are staying there. For what? For adoption or for the divorce or inheritance. Again, it will come under it. How? Of course, inheritance comes in the property. At the property law that we will see it. Whether the mobile property is there or immobile property is there. If the mobile property is there, we will see that law of the domicile will be considered. If the immobile property is there, what would be considered? If the immobile property would be there, what is the choice of law? Anyone?
The place where it is
Let's cite us where the property is situated.
Right, sir.
Where the property is situated, that country law would be applied over there. So we have another, still we do have many matrimonial issues, but we do concentrate on the cases. Each case law you take it, either a classical case law or the local case law, doesn't matter. But the principle should be come out from the case law. That is the important factor. And you check it because how many cases are there in this caption of the matrimonial conflict, and you read the cases, which case law comes and where, and that principle only we can just explain it enough. For the matrimonial causes are concerned. And in addition to that, please check the Law of Marriage Act. And the Law of Marriage Act, if you cite the section and the examiner will boost, of course, you cite the wrong section, he will check it. He will check it whether you cited a wrong section or not. If you cited a relevant section, then he will feel that, okay, he is having or she is having the knowledge of their country which section says over there, in addition to the connecting factor, in addition to the principles of the private international law, theories of the private international law. So that will be a quite good point to get a good marks there. But still we do have 5 to 10 minutes, but if you want to see the syllabus, and I will show you contemporary issues of private international law of obligations. What did you understand by the law of obligations here? What did you understand with the law of obligation here? Yes? If you know it,
Pass
you give
on,
me the
Prof.
answer. If you don't know it, you say the pass on.
Pass on,
Pass
sir.
on.
When you say the law of obligation, it covers both contract as well as the tort. See, I typed this. Law of obligation, read. Could you read it? Read.
Please zoom, Prof.
It is not visible properly. The law of obligation is one branch of private law under the civil law legal system and so-called mixed legal system. It is the body of the rules that organize and regulate the rights and duties arising between the individuals. When you say right and duties arising between the individuals, does it a tort or does it a contract? See, if you see here, what is the meaning of the obligation in law? Primarily, the popular meaning of term obligation is a duty to do or not to do something. In its legal sense, obligation is a civil concept. An obligation can be created voluntarily, such an obligation arising from a contract or a quasi-contract or a unilateral promise. So now, when you say the law of obligation means both tort and contract, because obligation arises from the contract also, obligation will be arises from the duty, rights and duty also, and obligation will arise from the quasi contract also, and hence obligations in a sense not only the tort, it includes the contract also. So terms in this set of 6, law when they are imposed by the law itself, contract when they arise from the stipulated of the parties, quasi-contracts, crimes, act or omission punished by the law, and quasi-delicts or torts or law. So these are all come under the obligations. Is it clear? Yes? Every obligation
sir.
has 4
Yes.
extensions. Yes, obligation in the sense either is a right and duties or obligation arises with a contract, obligation arises with a quasi-contract, or obligation arises from the unilateral contract. We can pass on the information to each. An active subject or a passive subject or a prestation under the rule. These are the elements of the obligation. So next class, mostly the Saturday, I don't think that I'm going to take your class on Saturday because I'm traveling to the Moshi to take few lectures plus guide them in the legal research in the Moshi Cooperative College in Moshi.
Okay.
So because if I reach over there, I may be tired by the time. I don't know, would you have direct bus from here to Moshi?
Yes, there is.
A good luxury bus that I would like to take so
Yes,
that I could
Professor.
not be get painful and clearly reach over there. But anyway, that I will inform you that because time being, I am giving the beginning only. There would not be any class on Saturday, and let us meet the next day. By that
Okay.
time, I will come with the certain cases in the obligations, both the tort and contract, and we will discuss what the principles are laid over there, and that principle is enough to understand the concept of private international law in both tort and contract. Okay? So with this, I would like to wind up today's
Thanks.
class. Yes. Anything that you would like to ask? Anything that you would like to ask?
Nothing, sir.
Okay. So goodbye and good day. Good night.
Good night.
Good night, not good day. End of the meeting for all.
Afrika, wabariki